you know.
Good evening. Welcome to the South Florida Hospital News and Healthcare Report legal webinar presented by Mirza Healthcare Law and the two partners of Mirza Healthcare Law. And we appreciate them doing this every month. We have a topic very interesting to mainly physicians, but really anybody who deals in a physician practice or knows of physicians, whether it be an accountant, an attorney, or whatever. Topics that could help your clients or at least light up the light bulb to maybe ask that question to see if they're in trouble and maybe keep them out of trouble. So with that, I'm going to go dark and I'm going to turn over to Ben and Ed.
Charles, thank you again. It's been a really nice summer, and it's nice to kind of start up the season again with some really impactful material like the Stark laws. And thanks for hosting this as well. And thanks to Broward County Medical Association and the Dade County Medical Association for also recasting this stuff out. So today we're going to be talking about Stark laws. How can physicians and hospitals avoid problems and still work together?
You need to put the slides up. You're looking off your other screen.
Oh, sorry.
Yes. Yeah, two screens.
Share screen. How about that? Does that look all right? Yeah. Okay.
That's a lot better.
All right. Perfect. So today we're going to be talking about Stark laws primarily. And before we get started, here, let me start the slideshow slide from the beginning. And there we go. So just a little bit about myself. My name is Ben Mirza. I am an attorney. I've been practicing for over 21 years. And I've got several other certifications, including that of a CPA, formerly also certified healthcare compliance officer. I've got a bachelor's degree in accounting, a Juris Doctor in law, obviously, and then a LLM of tax law, focusing on corporate mergers and acquisitions, and a master's of public health from Yale, and literally in that same order. I've worked for like large firms, small firms. I've worked for like large size institutions, and including places that had like 15, 20,000 sort of employees. But nonetheless, we run our own practice today as we go through the ebbs and flows of life. At this stage of our life, we choose to practice on our own. And today's topic is really about Stark law. And Stark law is really a highly, highly technical field. Most healthcare attorneys do work on the periphery of it, but there's very few people that are literally like delved into it as deeply as my colleague here today. And of all the people I know on the planet, he's got to be in the top 5 who understand Stark law. And that's Ed Meyer. Ed, you want to talk a little bit about
Well, thank you. One of the 5 people you actually know. No, I was just kidding about that. But no, I'm Ed Meyer. I am of counsel to Mirza Healthcare Law Partners. I've practiced law for 30 years, a little over 30 years now. My background, Georgetown Law, Stanford undergrad, and I've worked for for-profit health systems, individual hospitals, large physician groups, national physician groups, as well as individual physicians. And a lot of my work deals with dealing with the Stark law. I am licensed in California, and so I deal with federal issues if it deals in Florida. With regard to my background in Stark law, actually, my background goes back before I was even in law school, when Tony Stark was making his Iron Man outfit. No, just kidding about that. But in reality, when Congressman Pete Stark, on the Ways and Means Committee, was actually beginning his drafting of this Stark law, I was a young legislative assistant to a member of the Ways and Means Committee, and was in the room when Stark was sort of formulating his concern. This is a congressman who was the head of the health subcommittee that was concerned about physician referrals to businesses in which they had a financial interest, and making bright line tests to it, because in his view that referral arrangement caused an increase of cost to the Medicare program. So that's sort of my background on it. So I've always been focused on it since the very beginning.
So today we're going to talk about Stark laws, and I looked at the Department of Justice website, just yesterday again, and I visit there frequently. I actually look at the website quite often. The opioid crackdown is still continuing. There were again more opioid busts. Recently, there was a physician that was sentenced. That was found guilty. He hasn't been sentenced yet, and he had actually prescribed 111,000 pills to just 9 patients. Apart from that, he had his regular stream of patients, but 111,000 pills over a period of 5 years on these 9 patients. So that kind of tells you, like, these guys are taking this stuff. Either the world's out of whack or the Department of Justice is coming. The other thing was that I also noticed was medically unnecessary procedures. Those are continuing on in our industry. People are actually prescribing procedures that they shouldn't be. There was a $34 million fine recently having to do with that regarding physical therapy. People were getting paid for prescribing physical therapy. Another thing, just as a side note, there are also things going on in the marketplace, and you'll probably see more of this in the next couple of years, is the MRA, the medical risk assessment scores. Those are people are working on those considerably, and they're probably going to go up in the next couple of years. And I bet you there will also be a crackdown as to that. The other thing that I also saw was that in Florida, there were 3 regional hospitals that took part of billing for testing labs that they tended to have in the actual hospitals. And there was $1.4 billion that was billed out from those 3 hospitals, plus there was one more out of Georgia. But here on this slide, I list the ones that were there, and which cities they were in, actually. Williston, Graceville, and Putnam County. And that was a $1.4 billion billing issue, right? That came up. And that's obviously illegal. And, with that said, I mean, today's presentation is really intended for general information purposes. So you kind of get a lay of the land, what's going on in the marketplace, and how to navigate your conversations and discussions and strategies as you go through them. Just remember, today, this is not about legal advice. We are literally a seminar that is open and live, and it is being recorded, and it will be placed online. Ed, anything you want to add to that experience of Stark Law issues?
No, just what happened recently, or I guess the last year, 2 years ago, is that they updated the Stark Law. They added changes and modifications and whatnot, largely to make it a bit easier to deal with, even though it's quite complex, to make it easy and answer a lot of old questions that people have been wondering about. And that's kind of where we are today. There hadn't really been a change in the Stark Law since 2015, and so they updated it in 2020. I don't necessarily think there'll be any additional changes in the law, in the regulations, other than you'll see, other people trying to enforce it in lawsuits going back and forth on it. But this is a really good time to refocus on the Stark Law, because especially that the government is going to be focused on compliance and trying to oftentimes trying to find more revenue and through reviewing non-compliant arrangements.
Most administrators and most physicians are pretty well aware of the kind of return the Department of Justice gets every time they prosecute these cases, and what they get out of it. So it is a real wolf at the door that I think every healthcare practitioner, whether they're on the admin side or on the professional license provider side, they need to be concerned about, because it often raises ethics among physicians and their practices. There's actually practices that are out there where people are paying for literally referrals that go from a practice to a lab, or a lab to a practice, and so forth. And it's a problem of ethics, and it's got big financial repercussions.
Right. And like remember, I want to add one other thing is, we're going to talk about the changes in the law, but fundamentally, the Stark Law basically says if the physician has a financial relationship with an entity, be it a hospital or another physician or anything like that, then that relationship must fit within an exception if that physician is referring certain designated health services to that entity, and that entity is billing Medicare for those services. I just want to make sure we said that off at the very beginning. That's what we're talking about. That's what the
Yeah,
Stark clause says.
we're going
We're
to
gonna be
discuss
talking
those a
about-
little bit later on once we get to that part of it.
Yeah.
Yeah. So, all right. So today's presentation, we're already into the 50 minutes, but it's really about 50 minutes. First, we're going to talk about the general modernization that's taken place in the last year. Then we're going to talk a little bit about value-based arrangements and what have been the big changes there. And then we're going to talk about the safe harbors that pertain to the new safe harbors that have come about. And in the end, hopefully we'll have a little bit of time left for Q&A. But we're going to go through this pretty quickly and very in depth at the same time. So starting off, yeah, as Ed was saying, there has been a significant amount of modernization that's been done of the Stark laws. Number one, to clarify commonly used terms, because they weren't always clear as to what they included or didn't include. You know, it updated the existing Stark exceptions as well, because some new ones were added. And also, the one thing that CMS really wanted to do was they wanted to encourage value-based arrangements, because in the end, the way to contain costs, the overall healthcare costs, was to go through the value-based care business model. So as we talk about it, you'll see a lot of that coming through. Ed, you want to talk a little bit about
what happened to
the
one of the first things that was done in these updated regulations is they realized that there were a lot of terms that are commonly used in the various exceptions. And that is the concept of fair market value, the concept of commercial reasonableness. What does volume or value mean? And what they did is they clarified what these definitions, and actually added the definition for commercial reasonableness, but clarified and provided guidance to those who are going through these regulations, these Stark exceptions. And so it's clearer what they're actually talking about. So for example, in the fair market value realm, that fair market value is a fundamental concept that to meet any of the exceptions, that's on almost every exception to the Stark law, that the arrangement has to be fair market value plus meeting all the other elements of a particular exception. So the value, and they basically clearly identified it as the value in an arm's length transaction consistent with general market value of the subject matter. And it's important that they use the phrase general market value, because in the past, people were really stuck on, well, I have to get a salary survey. Let's say we're dealing with comp, and it has to be within a certain range within a salary survey, even though it didn't really say that. But this basically is sort of liberalized the concept, and this what's in the general market in your area for these type of arrangements. So for rental of equipment, it's the rental for general commercial purposes, again, without taking into account the intended use. Similarly, for rental of office space, it's for rental for general commercial purposes, not taking into account intended use, and without an adjustment for the additional value regarding the proximity or convenience to the lessor, or where the lessee is a referral source. So if you basically remove the fact these are in the healthcare arena, healthcare potential referral relationships, and it's just general commercial routes that you would otherwise see. So next slide.
Well, so question, Ed, if a physician wants to rent space inside a hospital, can the hospital charge them above market rates for having the physician house their practice inside the hospital?
No, they can't. So it's as if that rental space has the same elements within it, the same conveniences, the same equipment and size, etc., that it would find across the street in a non-hospital setting. If there was something of that sort, that would be considered fair market value. But to say, well, because you're now close to the hospital, we're either going to charge you more, or because the hospital's thinking you're going to get referrals, charging them less than what you normally would do in that market. that is falling outside the fair market value.
Thank you.
So with this concept of general market value, they really split it up into three elements, or three type of arrangements that where they focused on: assets, and then asset purchases, or leases of assets, equipment, compensation, and then rental of equipment and office space. So regarding assets, what's the general market value of an asset? It's the price the asset would bring on the date of acquisition of the asset as a result of bona fide bargaining between well-informed parties, and not otherwise in the position to refer or generate business to each other. Regarding compensation, like the payments to physicians, compensation is paid at the time the parties are. That's market value is the comp paid at the time the parties enter into that arrangement as a result of bona fide bargaining between the well-informed parties that are not otherwise in a position to generate business. And very similarly, on rental of equipment and office space, the price that the rental property would bring at the time the parties entered into the rental arrangement as a result of bona fide bargaining between the well-informed lessor and lessee, and without being in a position to generate business for each other. Now, we underline these phrases: on the date of acquisition, at the time the parties entered the service agreement, the time the parties entered into the rental arrangement. That's because oftentimes what I've heard that someone goes, well, it's fair market value when they entered into it, but now it's no longer fair market value. So now it's outside the fair market value rule. Not really. It's fair market value at the time that arrangement was entered into. As long as it was fair market value at the time it was entered into, that meets the fair market value element of the exceptions. Now, there's other elements. We'll talk in a second, commercial reasonableness. The question is it commercially reasonable to continue an arrangement that's no longer fair market value? But if it's fair market value at day one, you've met the fair market value piece of that. Then you have to turn, if it's no longer fair market value, let's say after 3 or 4 years, you have to go, especially now you're dealing with inflation, right? You might have to deal with that. The question is it really commercially reasonable to continue that? You look at the contract, are you able to terminate the contract or revise the contract to make it more reasonable? You want to say something, Ben?
I've got a question for you. What do you think is the normal term period for physician compensation to be like hold still? Like, like that whole 2-year thing, like, what are your thoughts on that? Like, what's like the generally accepted
employment agreement? Okay, well, now we're kind of getting to a ton of a different area in a way, but in employment agreements, they go, let's say, I've seen them for 1 year, 3 years, 5 years, as long as even 7 years. But when you have long-term arrangements, there was a recent case in Nevada where the antitrust folks said, look, this is a physician contract that has a 7-year term, and that has a non-compete in it that's going to last for 7 years. That they felt that was, wow, that's really violating the antitrust law. They felt that it was violating the antitrust laws, or questioned that. So it for purposes of fair market value arrangements, it could be any term for fair market value. But then when you get a longer term, you start implicating other concerns that might be out there, other laws that might be out there.
Hey, Ed, I got a question for you.
Sure.
Charles. What about the services where you have companies coming in, renting beds or space within a hospital, that patients are transferred from this area to like specialty care, or then maybe back to the hospital? How do you get those out of, I mean, it's done a lot, so I assume it's not within the Stark law, but is there something special that needs to be done in those arrangements?
I don't really understand it. So like,
there are companies out there that actually provide, say, what the old term ventilator service, okay, long-term acute care within a hospital, but it's not the hospital. It's a separate company that's renting beds or space within a hospital to do that. You also have that with hospice companies that rent space within the hospital to handle that. So I guess those arrangements are fine because they're different.
Well, no, they're. I mean, if you're dealing with designated health service referrals, that's where the Stark comes in. And what you're dealing with is they have exclusive use for that particular space that they're renting.
Right.
And we're going to talk in a moment about the rental of space arrangement. where it's exclusive, except that means that the lessor, the landlord, the hospital, that's a landlord, can't be using that space at the same time.
Gotcha.
That's
Okay.
yeah.
The other thing on that is, well, I guess when we
Yeah,
hit that slide.
we'll get to that
Touch on
second.
it.
But
We'll get
commercial
to it.
reasonableness, what's important here is there wasn't commercial reasonableness is an element for many of these exceptions. They have to be, to meet any particular exception to the Stark law to allow the arrangement, it has to be commercially reasonable. Now, there wasn't a definition for that. So they actually added one, thankfully, that's as follows. Their arrangement must further a legitimate business purpose. It has to be sensible, considering the characteristics of the parties, including their size, scope, type, et cetera, and specialty. And when they added a real important element is an arrangement may be commercially reasonable, even if it does not result in a profit for one or more of the parties. And that's sort of often happens in, let's say, the nonprofit world, where a nonprofit hospital has an arrangement where it loses money because it is serving underinsured population, and so it feels it has to do this arrangement, even though let's say, hire a doctor and they're losing money on it, because they're serving an underserved population. And that by adding this element of doesn't have to have a profit. If it doesn't have a profit, that means it's not automatically considered commercially unreasonable. That sort of puts aside potential lawsuits on that's non-compliant with Stark. They added that for that, I think, that specific reason. Next slide. And then they added, discussion of volume or value-based definitions. If it's like a unit-based comp, that would not be considered as a volume based on referrals if it was fair market value for the services actually provided, and does not vary in the course of the comp arrangement. That takes into account any referrals, and also physician comp that takes into account volume of value referrals is only if the compensation formula itself includes a physician referrals as a variable. That results in an increase or decrease in the comp to the physician that is corresponding to that number of or value of referrals. So that was an important addition to the definition. And they clarified the referrals. The referral does not include certain items or service in which a physician may be compensated. That's not within the definition of referrals, especially if you're dealing with value-based services. They clarified certain designated health services and the definition of those, and remuneration. That means furnishing items of service supplies. And they clarified that certain things such as tools, certain things, I put it over here, dealing with like specimen collection. So if you're, specimen collections, transporting specimens, processing specimens are things that are not really considered remuneration. So they kind of gave some relief to the device and the labs on that. You want to talk about rental and office space again?
Yeah, back to the rental space issue, and I think Charles had a pretty interesting question. How would you handle a situation when when somebody rents out, let's say, 10 beds in a hospital for, let's say, whether it's for the mental ward or to provide like mental health, behavioral health services or specialized sort of other services inside a hospital arrangement. From what I had seen, Ed, I've seen it where they run at a profit, and I've seen them run at a loss both ways. For the hospital, that is, if like, let's say the hospital is the landlord. What are your thoughts on that?
Well, again, the landlord has to rent space, and has to be exclusive. If they're renting a space, where the bed is located, that has to be exclusive use by the user. Now, there could be a problem if let's say they're losing money at it. Let's say they're renting at below fair market value. If that arrangement is for they're doing it because they go, well, this is a great referral source because we'll have rent space to this person and then this company and then they'll end up referring their patients back over to us. So that could be problematic actually.
Makes sense.
So you want let's go back and just clarify with this the exclusive use so that the office clarifies that lessor is only the party that's excluded for use. The exclusive use means the lessee used the office space to the exclusion of the lessor. The lessee could use it, can include other folks within it, but the landlord can't use it. Let's say with regard to common areas, they did clarify that, use of common areas, that does not, and the landlord using those common areas, that's fine as long as the tenant, the physician, let's say, who's leasing it from the hospital, and where the hospital is also using the common area, that tenant is actually paying their proportionate share based upon their portion of that they're actually leasing, where they have the exclusive use. So they have to kind of split up the costs of that common area and make sure they're actually paying for use of that common area.
That makes good sense. Right.
And they added this. This is really interesting. They added this, and this is a kind of a savings thing. Saving everyone from these little nuisance start provisions where someone goes, you know what? We hired it. We had a doctor couldn't make it to do reads, and they have to call in another doctor at the last minute to do reads. Doctor says, well, I'll do it as long as you pay me X dollars because that's what I normally charge for it. They go, sure, we'll pay you this amount of money. They pay them, but they forget to ever paper the arrangement. And someone goes, oh, start problem. I'm going to go up to the hospital on a start key tam or something like that. Or you just forget to sign something with the doctor. You technically fall outside of an exception. So long as the aggregate comp to the doctor or the referral source is $5,000 a calendar year or less, and the items are provided by the physician to the entity or services, and is not, that comp is not taking into account the volume or value of referrals, and it doesn't exceed fair market value, and it's commercially reasonable. As long as you're meeting that $5,000 exception, you're fine. It's like an exceptionally kind of an exception outside of all the other exceptions. So kind of to avoid these small comp problems where all of a sudden someone says, oh my goodness, we had this a little bit of dollars to a doctor, and now all of a sudden we're non-compliant. That's that. If you fall within this $5,000 exception, you're going to be okay. Next one.
Okay.
Now this is really important for now everyone's focusing on value-based care. So Stark added these value-based arrangement exceptions. And the reason why is because if you're going to be taking on risk, you're going to most likely have arrangements within that overall risk arrangement where multiple providers are taking on risk. We have the hospital and the physicians get together and we're going to take on risk from the payer, but we have to have certain referral requirements so we could manage that risk well. Well, if you have these referral requirements, someone goes, oh, you're paying for referrals, and that's a problem. So they added these value-based arrangements, so you could bundle up a set of services under with a payer, and get paid by the payer under a bundle of services. And as long as you're falling within these one of these three value-based arrangements, you can not have these referral arrangements within that enterprise. So let's look at the first one. Well, first let me talk about what value-based arrangements are really particularly. It's to fall within these exceptions, you have to have an arrangement that provides at least one value-based activity, activities of value to the payor that targets a population, and it's among the it's between among the enterprise and one or more of the participants, or between participants within the enterprise. So there's like a hospital and a physician group getting together, telling a payer, hey, we will take on risk for taking care of population within a particular county that has a specific condition. So we'll manage that for you. You pay us X dollars and we'll manage that arrangement. And we'll bundle that. You'll pay the bundle all services together and pay for that, but we'll take care of that for you. And but you have to fit these arrangements within these exceptions. Next slide. So it's important, understand these. They have specific definitions for what a value-based activity is, target population is, and the enterprise and the participants. And I won't get into those particular definitions, but just know that if someone's working on these, you have to make sure that you're drafting them according to those definitions. So we're talking about a full risk arrangement. So the enterprise, that means the participating folks within it, the doctors and the hospitals, and the other providers that might get together jointly, go to a payer. They have to assume full financial risk from the payer for the patient services of a target population. And specific services for a target population, and they have to be at risk for the cost of all patient care for that are covered by the payer for that particular risk arrangement, for which they're taking risk. And if it's Medicare, they have to be responsible for all services under Parts A and B. And they're given basically 12 months from when they start up that arrangement to get under the full financial risk. So obviously, if you're starting these things up, you cannot all of a sudden abracadabra be at full risk. You have to kind of get up to put all your things in place, and then get there. So they give you 12 months, and if you're at risk, you can't also get other additional payments from the patients, or you can't bill separately for these things for which you're at risk. So you're at risk, you really are at risk to fall under this full financial risk value-based arrangement exception. The other exception is this one for meaningful downside risk.
Oh, got it. Okay. Yep, there it is.
Downside risk. And that's where the physicians in this arrangement are responsible are basically they forego, or they have to repay at least 10% of what they get. So they could have a 10% withhold, or if they don't meet the requirements, then they have to pay back 10%, at least 10%. Now, it was originally proposed at 25%. So this made it easier for these value-based arrangements that are on this downside financial risk exception. But the comp includes total comp, not just what the physicians are getting from let's say the enterprise or from the hospital to enter into this, but all comp, including any other sort of infrastructure and care coordination services that might otherwise be provided to them by the enterprise or the hospital. So you got to take all those things, value them up, and about at least 10% of that total value, the dollars the doctors are going to get, and the infrastructure and the other care coordination that might be provided by the enterprise, that has to be all added up and totaled, and then at least 10% of that total value has to be at risk for the physicians.
Ed, can you go into, and I guess
Sure.
dealing with the downside and I guess an upside to a certain degree, how this pertains to an ACO, if it does at all?
Yeah, I would need to think through that a little bit more, but I think what we're dealing with is the if that ACO is having referral arrangements within them. So the ACO doesn't necessarily have an arrangement where they are required to refer specifically designated health services to the other participants in the ACO. So that's where it kind of comes a little bit different.
Okay.
I hope I answered your question. And then, and the nature of that risk has to be in writing and has to be set in advance. But you have to be very careful that there can't be any incentive to reduce any or limit medically necessary services. And the value-based activity, the payment for that is for the target population and not for patients outside of that target population of which they're taking on that going to the payer and saying, well, we'll take on that risk and have this enterprise value-based arrangement with the payer. And there's other requirements that are in there. Next slide. And then the final one, there's for these value-based arrangements, isn't really a risk arrangement, but it's more like you have to meet protocols and measures, and the measures have to be set out in advance, and they have to be prospective, and they have to be monitored. And if they're not met, then the arrangement has to be terminated immediately, or terminated, I should say, after it's not effective. So, you have these value-based activities. The value-based arrangements are expected to further that purpose of that value. Again, talking about value-based activities is thresholds for patients doing better and physically better, their conditions improving of that target population. Or let's say, I would say we're dealing with just to come to mind immediately is OBGYN and let's say breastfeeding and that sort of value arrangement where they have these targets for breastfeeding might be one of the targets that are out there. And but the outcomes have to be measurable and selected based on clinical evidence or credible clinical support. Next slide. I guess I'll
Favorite
talk
part,
about.
Ed. This is your favorite part.
Oh, that's my favorite part. The anti-kickback statute. This is the kickback statute is a criminal statute. So Stark law is a bright line test statute. You got to meet it. If you can't meet it, if you don't meet it, you can't make referrals for these 10 designated health services. But it's a civil statute. But it also implicates false claims, because if you're making claims based on it, then and you're not compliant, then it could be a false claim. That's then has these big fines on it and subject to key TAM actions. So, but now you're talking about the safe harbor. I mean, the kickback statute, which is a criminal statute, and you can't have kickbacks. You can't provide something to induce a referral. And there are 7 new safe harbors that were added, and 4 existing ones were modified, as well as a new exception in the civil monetary penalty statute regarding beneficiary inducements. So with regard to the 7 new ones, basically 3 of these effectively mirror those Stark law exceptions I just talked about for value-based arrangements. So if you're ending to a value-based arrangement and you're compliant with it and with the safe harbors, you don't have to worry about not just the kickback, not just the Stark rule, but also the kickback statute. And then there are there's another new safe harbor for patient engagement and support, and that deals basically with providing tools or support to the patient and these value-based arrangements that assist them in participating in the arrangement. So generally, if you give something of value to a patient to get them to do business with you, that could be implicating the kickback statute. But these patient engagement support, when a company and part of these value-based enterprise arrangements, then there's a specific safe harbor for how that is done. Similarly, they dealt with this donation of cybersecurity technology. They added that new ones, and they also added a new safe harbor for remuneration provided in connection with a CMS sponsored model. And that basically means, sometimes CMS sponsors these models, but if someone engages in it, they go, wait a second, I might be violating the kickback statute. So issue me a waiver. And so instead of having to issue these waivers all the time, they added things that if you're under the CMS sponsored model, then you automatically are under a safe harbor. But they also they modified certain safe harbors, which is the next slide. So on electronic health record items and services regarding cybersecurity, they added protections related to cybersecurity technology. They updated provisions regarding interoperability. And originally the safe harbor was to sunset, and they removed that sunset. So now it's a permanent safe harbor. With regard to personal services and management arrangements, they modified it so that outcome-based payments and part-time arrangements add provisions regarding that. What's interesting too is they dealt with this local transportation safe harbor and local transport. They basically says in rural areas, and I used to work for a rural hospital, by the way. And so you always have this issue like you don't really have good transportation in some of these rural areas, so like bus services and whatnot. So these hospitals can have these free transportation services for up to 75 miles in these rural areas. And significantly also outside of just simply rural arrangements, they removed the mileage limit for transporting a patient after an inpatient admission or after 24 hours of observation. It's back to their residence. So if they're not transporting them to the hospital for inpatient admission, but once they're completed, if they need a ride or need to be transported back after an inpatient admission, they can be transported no mileage restriction to their residence, and they kind of broaden the definition of residence. It includes even a homeless shelter, but it does not include to another hospital. So if you're transporting from hospital to hospital, you would not fall under this safe harbor. You have to find another way to arrange to deal with it. And there were also they modify the warranty safe harbor, because a warranty, it can be let's say a device manufacturer or it gives a warranty to a hospital, that might be an inducement, or they're warranting it for them to actually buy their stuff, right? So there had been a safe harbor that was very, very narrow, and so what they ended up doing is broadening it so that you include bundled services and items that are together under the warranty, and adds protections against the bundled warranties of one or more items and related services to it, but does not extend to just simply warranties of services only. So they added, if you're dealing with warranties, you want to be able to look at this warranty exception, or safe harbor, I should say. Next slide. And finally, I think we're dealing with the civil monetary penalties for telehealth. So if they have a specific carve out for telehealth technologies when provided to an individual in home dialysis receiving end-stage renal disease treatment in their home under Part B. So they can actually get telehealth technologies to them, but they can't be advertising they provide this. And again, that provider has to be currently providing that inpatient home dialysis to that patient, or that patient themselves have initiated the selection or contacting that dialysis provider for services. They can't, in other words, the dialysis provider can't be using the fact they give telehealth to try to get more patients. And again, it has to be provided for the purpose of providing telehealth services. It's actually related to the ESRD of the individual. These all became effective January 19th, 2021, except that the value-based arrangements exceptions and safe harbors became effective in January 1, 2022. So with these value-based arrangements, you're going to see more and more folks looking to see, can we use this? And I keep reading in more and more of these trade journals in the healthcare field that value-based is really the way that they're going to, that payers are looking to basically reduce their cost. And if you're in any of these arrangements, a value-based arrangement with a payer and where you're bundling services together with others, you want to make sure you're fitting within the Stark law exceptions as well as the kickback exceptions.
All right. Well, thank you, Ed.
Welcome.
Man, I love your stuff because I tell you, even though I'm in this area of law, I learn something from you every time you speak. So thank you.
It's a lot of regulation, a lot of requirements.
Yeah.
To make sure you're
Any questions?
Ed, could you give an example of something maybe 4 years ago, that was a stark violation, but because of the change in the rules, is no longer a stark violation?
Yeah, I mean, I think I mentioned it. What a perfect example where, let's say, a hospital needs to have a physician come in and, let's say, review records for them. And the hospital then pays the doctor to go review those records, but they never paper it. They never put it in place. That normally would be a violation of the Stark Law, because the Stark Law requires that personal service to be in writing, be said in advance, and to fit within the exception. But now you say, hey, look, we never paid him more than $5,000. And what we paid him was really kind of the going rate to do this. Now you're okay. Similarly, another one would be like the dealing with the office space, where you leased office space to a physician, and that physician also allowed others to use it. So it was not exclusive to the physician. Now it's just clear that as long as the landlord's not using it, that space, then the physician uses it, have someone else use it. It's not an issue.
How would something work where some physicians are selling third-party products from their office for their patients? I mean, legitimately, I'm not talking about you trying to.
Yeah.
You
Physicians sell the third-party product to it. Now, it becomes an issue if they're selling it to a referral source, or if they're a referral source to that person purchasing it.
Well, let's say that they are they have the product within their office, but it's on a contingency compensation basis. If you sell it, you get 20% of the price or something like that. Is that a violation?
Well, it's
Like,
only
like a CBD oil thing, like something
Well,
like that.
that, or I mean, or a device. I mean, let's say you got somebody, and the biggest thing that I can think about is like hearing aid type situations, where they may not own it, but they get a percentage if they sell a hearing aid by the company to ask them to say, sell this one, and I don't know. I'm just kind of throwing stuff out.
The hearing aid, it's not dealing with hearing aids. Hearing aids I don't think hearing aids are reimbursable by Medicare, but they are reimbursable by Medicaid, and that may not implicate the Stark Law in the first place. But there could be a kickback arrangement if,
Right.
let's say, they're giving them, if these are, again, because the kickback applies not just to the Medicare program, to any federal healthcare program.
Right. Mm-hmm.
So if you're, let's say, giving, if a hearing aid thing, say, well, we're just going to plop our hearing aids in your office, and if you sell them, you sell them. If you don't, and you get you have to pay for them, but otherwise you're not going to pay for them. That I think that creates a potential problem if they're just sort of then on consignment. They have to have that arrangement. It has to be commercially reasonable. It has to be all written down, and be fair market value for what those arrangements would be.
Okay. So if it was a fair market value arrangement, I mean, there wouldn't be anything wrong with it. Paying the physician a commission for selling a product to a patient.
As long as it's fair market value, I think you're, if you fall within those exceptions.
Okay.
Ben, you have something you want to say about that? Oh, you kind of made a face.
No, I was just thinking, well, a couple of things I was just thinking. One is like CBD oil would not be covered by like Medicare, right? Or
Right.
Or typically wouldn't be paid for. So products like that or vitamins would kind of fall outside of that, right?
Well, no, it does. It still falls in Stark because it's a financial arrangement. So anytime you have so like even like a pizza, let's say, the example that used to be commonly used is the hospital orders pizza from the wife, a physician's spouse who has a pizza parlor. Okay, they order those. They don't have anything in writing, and let's say it's more than $5,000 a year in pizzas they get from them, because now you're outside that $5,000. That could be a problem because now you have a financial relationship regarding all those pizzas that then says that relationship better be fit within the Stark exception. Otherwise, you can't make any referrals to designated health services. So it's not tied specifically to that particular arrangement. You want to make sure that it's any referrals that go back and forth that are designated health services. You have to look at the compensation. Does that compensation any type of compensation that's out there, does that incentivize, is it fit within an exception? Because this, again, Stark, going way back to the beginning of Stark, he's saying, look, Mr. Stark, not Tony Stark, but Pete Stark. He's saying, ladies, hospitals are having these financial arrangements with doctors, and because they have that in place, they're getting these doctors to refer these 10 type of services to them. And so they have to make sure anytime you have a compensation arrangement with a doctor or any referral source, you have to fit within an exception. That arrangement has to fit within an exception. Otherwise, no designated health services can go back and forth.
What about Ed? What about labs? I mean, that's one that always
yeah.
That's
what added these exceptions for labs made it a lot easier, a little bit easier for these labs because the specimen going transport back and forth, and the use of the collecting specimen, the cost of collecting specimens, processing specimens, storing specimens, and whatnot. They kind of carved that out of what remuneration was, what the value was given to them. So that helped the labs out. But let's say a lab wants to locate in a hospital or in a physician office, a perfect example.
Right.
You have a physician office and a lab says, hey, we want to locate in your physician office. Well, you got to have a rental arrangement. It has to be fair market value. And while it may be convenient for the patient, it still has to fit within all the exceptions to a Stark arrangement for that.
What about companies that bring in, I know different devices? I don't know what it might be. I wouldn't say an X-ray, like a portable X-ray to a doctor's office that doesn't have one, or an MRI, whatever machine there may be. Doctors will come here on Thursdays because we have this machine here and we can do all this stuff for you, but they don't have a permanent place. They just set it up and take it away.
Yeah, they have to make sure they're renting the space.
So they don't need to rent. They can rent the space. It doesn't have to be a permanent rental. It can be a rental on every Thursday that you're renting this space.
Yeah, in fact, the rental space, they got rid of this requirement that you had to have a specific schedule set up, in advance. Before, that used to be the way. That's a good example of how things have changed. Mm-hmm. You can still do that as long as you have the rent is for that period of time they're going to use it. It's set in advance, so every time you come in here, we know it's going to cost you X dollars when you put that thing in here to rent the space.
Right. And you can't, and the doctor can't be a recipient of any of the fees that this place charges. In other words, they charge $200. They can't get a kickback on that.
No, right? They can't get a kickback on that.
Okay. You've answered all my questions.
Right. Thanks, Miguel or Robert. It's not legal advice, but just educational.
Yeah, this is Robert. Can you hear me?
Yeah, I got you.
Okay, so going back to rental space, and the fair market value. As I understand what you're saying now, it's the fair market value for that square footage, no matter what it's for. Is that correct? In other words, I'm going to give you an exact example. A hospital leases space in an office building. They then want to sublet that to a doctor's practice because they have too much space there and it's not doing them any good. Okay, so they want to lease it to that doctor's practice. To determine the fair market value of that space, would you use what they are leasing their space for? Or would you then take a look at, since it's going to be signed at that time, the surrounding area of all businesses for that square footage?
I think that I might disagree, but if you already have a market set for that space, and that space was set without regard to any referral arrangements, that was it. Again, the hospital just rented a building. You have an outside building, right? They just went out and rented that building, right? But they obviously you have the TIs and all that sort of stuff. That's incorporated into that lease. They're renting it for X, and they can't. I think it'd be a problem if they turned around and went to the doctor and said, "Oh, by the way, we're paying X, but we're gonna not, we'll charge you less. Maybe you could do that because if like generally if you went to a landlord, or I mean a rental agent, and they go, look, it's not the whole thing, it's a different value because it's you would actually discount it a bit. You could probably get away with some argument on that. But if you're just simply saying, oh, hey, there's another space across the street or down the way, that's different, kind of different, because it's not really doesn't have all the TIs that are in there, and I would just charge that lower amount. That could be problematic.
Okay.
So when I've had my talks with like the FMV guys, what they'll generally do is they'll like draw a radius. They'll say, what class would this space be considered, A, B, C, right? And then they take a look at within that radius what that class A or class B space or C space looks like, and what the brackets are for it. And then they just basically say, look, you could probably rent it out between this amount and this amount. So whether it's $15 or $25 a square foot, it'll depend on that geography. And if you're adding on services to it, like for example, if you're giving them free cable and you're giving them free internet and you're giving them, free water, it's not really free, but it's all included, right? You got to do the tack-ons for that, and that's how the FMV companies will value something like that. But they usually don't do it based on, they'll look at class A, B, C, but they will not look at medical use versus office use versus some other use.
Right.
That's my experience, but yeah.
Yeah, I think that's right. That's right.
Excuse me, how do they figure out what that geographic area is? Okay, and the reason I'm saying that is in bigger cities, you can go 3 blocks down the line and change your square footage cost, okay, based on the area it's in.
Yeah, you cross the street, all of a sudden it's totally different, right?
That's correct. So how do you figure that
know.
area? How do you figure that area that they're talking about?
And I think they do look for like reasonable factors like that. Like if you go across the street and all of a sudden the rent drops by like $10 a square foot, they actually could take that into consideration. I don't know how they exactly do it, but I know that's been a part of our conversations before in assessing value.
The bottom line is you want a valuation. If you're dealing with this stuff, you should have a valuation consultant or at least get comparables on it. I would not just simply venture to say, oh, I know what it is. I know what fair market value is for this particular space. I'd get someone in this area who deals with this. The valuation consultants, be it a valuation consultant or a broker, deals with this stuff all the time.
Appreciate it. Thank you.
All right, Ben, how can people reach you if they need to kind of consult with you and Ed?
So if anybody wants to reach us, here's the slide for that. And if anyone has a question for Ed or myself, they're welcome to call us. Ed's phone number's on here. My phone number's on here. Our emails are on here. Feel free to reach out directly to either one of us. And we're happy to help you, even if you just have general questions.
Right.
And if you can't find either of our contact information, contact Charles, because he always knows where we are.
He knows where everyone is.
That's right. I can reach you anytime, any place, Ben. Just remember, I got eyes on you. Not a problem. So. Anyway, I want to thank everybody for being part of this webinar, this legal webinar today. And this will be up on the website, hopefully by the end of the day tomorrow. So you can see it on my website. Ben will have it posted on his website. And please share the information, because there's also a lot of people that missed it or would have liked to come. And it's, I think a good hour of your time listening and understanding. And obviously the questions going back and forth can be beneficial. And if they finish reading, if they finish watching it and have some questions, Ben and Ed are always available. So with that, I want to thank everybody for coming tonight. And we will see you next month. And Ben, do you remember what next month is all about? Have you got that down?
No, I don't have it in front of me, but I think it's on non-competes.
I think
It is on non-competes. I have
non-compete.
signed non-compete. Now what do I do?
Yeah.
And there's some increased activity. I mentioned this case in Nevada. And that's Beck versus Pickard Medical Group, I think, where the antitrust folks intervened or basically signed it. Basically, they didn't intervene. They issued like an amicus brief to the court saying this is how we're viewing these non-competes now. So there's an increased scrutiny of non-competes. They've sent the a shot across the bow on these non-competes and how long they could be and what the antitrust enforcement people view them as.
Great.
That's actually on September 20th,
Right.
Tuesday,
Mhm.
September. And actually, Ed and I have been a part of some non-compete litigation, and it's a lot of fun. It's actually a lot of fun, but it is nerve-wracking for both sides because when two giants tango, there's a lot of force behind it also.
Oh, great. So hopefully everybody look forward to it. If you know anybody who may have that situation come up or is interested in learning more about it, tell them to tune in next month. So with that, hope everybody has a good rest of the week, and we will see you in about 30 days. Take care, everybody.
Thanks, everybody.
Bye-bye.
Thank you.
Bye.
Thank you. Bye.